Welcome to EU Privacy for All, Session 56 on GDPR, Right to lodge a complaint and to judicial remedy, Article 73, 4 and 5. Regarding Article 73 on the complaints to data protection authorities, European Parliament suggested no major change. It only added a reference to the consistency mechanism. On its side, EU Council suggested to refer to the right to lodge a complaint with a single supervisory authority, in particular the member state of his or her habitual residence, place of work, or place of the alleged infringement. Regarding Article 74 on judicial remedy against a data protection authority binding decision, European Parliament proposed the addition of the wording without prejudice to any other administrative or non-judicial remedy. On its side, EU Council proposed that Article 74(3)(a) would lay down where proceedings are brought against a decision of a supervisory authority which was preceded by an opinion or a decision of the EDPB. In the consistency mechanism, the supervisory authority shall forward that opinion or decision to the court. Finally, regarding Article 75 on judicial remedy against a controller or a processor, some provisions were deleted by European Parliament focusing on the competent member states' courts, and EU Council referred to data subjects' right to an effective judicial remedy. The final wording of Article 73 on the right to lodge a complaint with a supervisory authority confirmed the right to lodge a complaint with a DPA without prejudice to any other administrative or judicial remedy, as suggested by European Parliament. Moreover, as suggested by EU Council, it retained that it was applicable in particular in the member state of his or her habitual residence, place of work, or place of the alleged infringement. The supervisory authority shall inform the complainant. Article 74 on the right to a judicial remedy against a supervisory authority, it is stressed that without prejudice to any other administrative or non-judicial remedy, once again, data subjects benefit from the right to an effective judicial remedy against a legally binding decision of a supervisory authority concerning them. It is also made clear that without prejudice to any other administrative or non-judicial remedy, this right to an effective judicial remedy where the supervisory authority competent has not decided to deal with a complaint or does not inform the data subject within 3 months shall also benefit to data subjects. The proceedings against a DPA shall be brought before the courts of the member state where the supervisory authority is established. Finally, where proceedings are brought against a decision of a supervisory authority which was preceded by an opinion or a decision of the EDPB, the supervisory authority shall forward that opinion or decision to the court. Finally, Article 75 on the right to an effective judicial remedy against a controller or a processor lays down that without prejudice to any available administrative or non-judicial remedy, each data subject shall have the right to an effective judicial remedy against a processor or a controller infringing the regulation and data subjects' rights. It is also outlined that proceedings against such a controller or processor shall be brought before the courts of the member state where this controller or processor has an establishment. A second option, whenever the controller or the processor is not a public authority, would be to bring the case before the courts of the member state where the data subject has his or her habitual residence. Another key provision in the GDPR is recital 111. It basically reminds all the points made in Article 73, 4 and 5, plus operational insights. That is to say that the investigation following a complaint should be carried out subject to judicial review, and that the supervisory authority should inform the data subject of the progress and the outcome of the complaint within a reasonable period. Intermediate information should also be given to the data subject. And finally, supervisory authorities are incentivized to take measures such as providing a complaint submission form, which can be completed also electronically. Currently, Article 28 of the Directive lays down that decisions by DPAs which give rise to complaints may be appealed against through the courts. Each DPA shall also hear claims. The person concerned shall be informed of the outcome of the claim, and finally, shall at any rate be informed that a check has taken place. What should accountable data controllers and processors get prepared for? First, regarding the right to lodge a complaint with a supervisory authority, this right shall be without prejudice to any other administrative or judicial remedy. It can be exercised in the member state of the data subject's habitual residence, place of work, or place of the alleged infringement. Each complainant will be advised on the complaint by the DPA to which the complaint has been lodged. Regarding data subject's right to an effective judicial remedy against legally binding decisions of a data protection authority, this right is also without prejudice to any other administrative or non-judicial remedy. It applies when a DPA does not deal with a complaint or does not inform the data subject within 3 months. The complaint will be brought before the courts of the member state of the data protection authority. Finally, regarding data subjects' rights to an effective judicial remedy against a controller or processor infringing the GDPR, it shall be made clear that the complaint will be brought before courts of the member state where this controller or processor has an establishment, or if this controller or processor is not a public entity, where the data subject has its habitual residence. The question triggered now is knowing more about an harmonized approach on complaints received by DPAs and by the courts.